Good evening. Welcome to the Palo Alto Policy and Services Committee meeting on June 9th, 2026. Will the clerk please call the roll?
Absolutely. Vice Mayor Stone?
Here.
Councilmember Rectal?
Here.
Chair Lithcott-Hames?
Here.
For the record, all are present.
Thank you. Now let's turn to public comment on items not on our agenda tonight.
We do have one request to speak. Our first speaker will be Monpreet S.
Terrific. You have 3 minutes.
Good evening, committee members. I'm here to request a review of Palo Alto barking dog enforcement framework. I live adjacent to commercial property in Barron Park area. Between our properties is a narrow alley. The neighborhood property keeps the dogs in the yard that directly face my house across that alley. The dogs are exactly 24 feet away from my bedroom window and routinely react to the activity in the alley, including the pedestrians, cyclists, and vehicles passing by. For more than a year, I have been working with the code enforcement regarding excessive barking from these dogs. Despite numerous complaints and ongoing communication with the city staff, the problem remains unresolved. My concern is that there appears to be a gap between the ordinance requirements and what can realistically be enforced. Under the current ordinance, a barking dog is defined as a dog that barks continuously and incessantly for 10 minutes within the 15 minutes window. I have been informed that the enforcement personnel must personally witness the violation and that video recordings from the residents are not accepted for enforcement purposes. In practice, this creates an almost impossible standard for many residents. The problem is that even more acute at night. 2-minute barking episode at 2 a.m. may be enough to wake up the entire family and disrupt their sleep, and yet it may not qualify for enforcement under the current process. The ordinance appears to assume that the dogs are indoors at night. However, in my case, the dogs live outdoors in the backyard 24 hours a day, 7 days a week. City staff has acknowledged that reasonable mitigation measures exist. For example, staff agreed that installing a visual screen could reduce the barking by preventing the dogs from reacting to the activity in the alley. Yet, despite that recognition, no effective remedy has been implemented. I'm not asking the committee to resolve my individual complaint. I'm asking whether the current barking dog ordinance and enforcement policies are achieving their intended purpose. I respectfully request the committee consider a future agenda item or a staff report examining complaint volume, enforcement outcomes, and evidentiary requirements, and whether residents have a practical path to relief from recurring dog barking disturbances. Thank you.
Thank you. All right, now we'll turn to our action agenda. The first item is our nonprofit work plan. Follow-up recommendation on the lease for the Lawn Bowls Club. Ms.
Thank you.
Alamos.
Good evening, Chair, Council members. Lupita Alamos, Assistant to the City Manager. And tonight's focus will be the discussion on the continued consideration of the Nonprofit Work Plan Phase 2, and specifically on the long-term lease framework, and to recommend Council extend the Palo Alto Lawn Bowls Club's lease. So the Nonprofit Work Plan consists of 4, next slide. Thank you. The Nonprofit Work Plan consists of 4 major bodies of work. Those are the Phase 1 funding requests that we had been working on, the multi-year service agreements, so strategic review of all grant programs, and then, as we're considering tonight, the nonprofit lease agreements. And that will help out that helps flesh out the nonprofit guiding principles. And we first came to this committee back in November 19, 2025, to discuss the nonprofit leases. We introduced the framework that we'll be talking about today to evaluate future leases that build on the 2022 audit recommendations and best practices, as well as the nonprofit guiding principles that were developed back in October of 2024. And then to test that framework, staff presented 3 long-term leases that were nearing expiration to serve as the leading examples to the framework. And those were Gamble Garden, Winter Lodge Tennis, and Palo Alto Lawn Bowls. The committee at that time reviewed the first two, and tonight's discussion will then address the third. Next slide. So to help evaluate the nonprofit leases, the proposed framework provided guidance on three overarching themes: the public benefit of the relationship, the financial relationship, and the stability of the partnership. Those were described and defined in the staff report. On that November 19th, 2025 Policy and Services meeting, we crosswalked each of the nonprofit leases to this framework and received feedback from that committee to return with more information and improvements to the public benefit theme, and specifically on public access and pricing for Winter Lodge Tennis and for the Palo Alto Lawn Bowls Club. The Gamble Garden had also been part of that, but since their grounds are open to the public, they felt like they fully met this first tenant. Next slide. So a little background on the Palo Alto Lawn Bowls lease. So they've been long-term partners with us since 1964. The property consists of lawn bowling green, clubhouse, and a storage shed. The annual rent is approximately $16,000 a year with 2% increases each year. And the Palo Alto Lawn Bowls Club is responsible for minor clubhouse maintenance, operating expenses, utilities, except for water and insurance. For this property, the city is also contributing to its maintenance of the lawn bowl green, as well as structural maintenance and repair to the clubhouse, as well as the water costs. This is approximately $55,000 annually. And the current 10-year lease expired back in March with a holdover clause in effect. I also want to acknowledge that we do have Sunny Tong, our real estate manager, that is online and available to answer any technical questions about the lease after this presentation. Next slide. Okay, so in this slide, we'll be covering the return of, with more information on access and pricing. Previously, the Palo Alto Lawn Bowl public access hours were only Sundays at 1 p.m. And to that, the previous Policy and Services Committee specifically discussed the limited public access and membership fees as barriers to public enjoyment of the property. So since then, the Palo Alto Lawn Bowls Club has responded to the committee's feedback and is now proposing the revised public hours that are captured on this table. So the public would be able to access the grounds during these times for an introduction, a demonstration, lesson, or just to enjoy the property of the grounds at no cost. So what that looks like in the summer hours in the right-hand side column is on Mondays, the property would be closed. Tuesdays, Thursdays, and Saturdays would be open from 10 to 1. Wednesdays in the evenings, they have opening hours of 5:30 to 7, and then Sundays from 1:30 to 4:30. And I was just informed that I believe that also now encompasses noon time as well. So during that time, the public can, as I mentioned, could come and access the property at no cost. The clubhouse is also currently available to the city when it's not in use by the Palo Alto Lawn Bowls Club. And since the club relies on membership fees, tournaments, and clubhouse rentals to pay its rent, it also proposes to reduce rental rates to the public by 10%. So that's an additional accommodation that while still maintaining its membership and rentals revenue, they could also offer a 10% discount to the public. But I would also still like to note that The grounds will remain locked outside of these public hours to maintain the integrity of the lawn bowl green. As the grass is very sensitive, we want to manage its misuse or access that would not be bowling. So if the, next slide. So if the committee recommends approval of the lease, tonight staff would be working with the Lawn Bowls Club on finalizing those terms, including adding annual performance measures and reporting, such as public use statistics, to ensure that the facility remains a public valued resource. Staff would also take the proposed framework and include it in the real estate policies and procedures for evaluation of future leases. And that concludes my presentation. Chair, back to you.
Thank you very much. Why don't we go to public comment next? Do we have anybody?
There are no requests to speak on item 1.
Okay, thank you. Well, thank you, Ms. Almos. And colleagues, who'd like to go first? Go ahead.
Okay.
Councilmember Rectal.
Yeah, thank you. Years ago, when my kids were very young, we were wandering by, and the door was open, so we went in, and people were playing, and the kids were just toddlers, or maybe early elementary, and the guys were so nice. They showed the kids how to roll it, and we must have been there for an hour, and it was one of the best times they had. And so that was a very fond memory. But now, we're always looking for things for youth to do, and could high schoolers be interested in this? This might be a good youth thing for a Friday evening or something like that, or maybe even foster intergenerational activity. So I like the lawn bowling, I want to renew the lease, but I also would like to incorporate more people, because I think it'd be healthy for the club to have more interaction and healthy for the kids too.
That's it?
Yeah, I looked online, there's 130 members, which is quite, I thought it would just be a handful of people, so I was quite impressed that we have that many people in the organization. So.
Okay, thank you. Vice Mayor?
Thank you, Chair. Just appreciate staff working with Palo Alto Lawn Bowl Club on this, and I appreciate the Lawn Bowl Club's willingness to expand those free lessons. I think this is, I think we've found a really good community benefit here that is kind of, I guess, worthy of the city's continued financial support and of this lease extension. So I appreciate it. Looking forward to. I've never tried lawn bowling. It does sound like fun. So I'll have to stroll in there sometime, hopefully this summer, and check it out. So I'll move the staff motion.
Second.
Would you like to speak more to your motion? No. Okay. Well, before we vote, I'd like to say a few things, ask a few questions, actually, but thank you to my colleagues for their comments. Unlike Councilmember Rectal, I didn't discover lawn bowling when my kids were young. I discovered lawn bowling when I got on the city council. It was yet another thing I learned about this great little city. Like, wow, we have lawn bowling. What is that? Amazing. We were tasked with really digging into, is this truly conferring a public benefit? That seems to be public access and pricing. And so I just want to drill into that a little bit. I know we've been comparing this particular partner with Gamble Gardens and Winter Lodge Tennis specifically. And I wonder if we have any data on how many members of the public annually use Gamble Gardens, Winter Lodge Tennis, and lawn bowling. Do we happen to know that, or do we have anyone here from Lawn Bowl that can help us with their number?
We do have 2 representatives from Palo Alto Lawn Bowls, but as they make their way up, if they have any other information on that, that is something that we're going to start requiring, is to get a sense of how many members of the public, how many members are utilizing the resource. So I'll invite.
Yeah, I would just comment that I think that's a good example of how what we're now establishing through this framework will set some hopefully common metrics that our various community partner organizations can use going forward that really have not been in place to date.
And I appreciate that. I think it's important. It's 2 acres. It's gorgeous lawn, clubhouse and 130 members, and which is fantastic. And Councilmember Rickdahl said he didn't expect it to be that high. It's a great number. I think it still begs the question, outside of membership, given that this is subsidized by the city, how many others are really aware of this? How are you reaching out and inviting people to know more? Hi there, sir. Welcome. Tell us your
Hi
name and
there.
your role.
Thank you, council members. My name is John Yee. I'm currently the president of the Palo Alto Lawn Bowls Club. And to your questions about the high school students, we do, not lately, but in the past, Castellea High School, their coach asked us to have the kids come over. So we did have them over to our lawn bowl club on occasions. Also, we lent them about 20 boxes of bowls and mats and jacks, the equipment, so they could practice on their artificial green in their middle quad area. So they had it for about 2 weeks. We do have some, I should say, middle school, high school, which a couple of the son and daughter, they come and play, and they do invite their friends to come and try it out. In order to help the city, the residents of Palo Alto, of course, we do open our doors, and now we used to have just Sundays for free beginning bowling for anybody who comes through our doors. Now we offer them to learn the game anytime when they come in. And we gave you Lupita gave you the hours and the days of the times we are open. We do have a lot of rentals from the high-tech areas in which they do come and use our greens as part of their, I guess, training or social events. And they love the game, but a lot of them live out of the city, and it's not convenient for them to join because they may live in the city or down San Jose. But they do show interest in the game, and it could range from anywhere from 10 to 40 people learning how to bowl. And we don't have any paid staff at our club. Everything's volunteer. So we have to recruit from our members, people who want to come volunteer for these rental to help the guests how to bowl.
Thank you. Mr. Yee, I appreciate your sharing this. We do. Do you have a way of tracking the number of non-members that are either coming for a lesson, dropping into play, or reserving the clubhouse also? I'm interested in.
Okay, we have people who come in just to learn how to bowl. We do have a waiver for them to sign, so we keep track of that. Other than that, our rental chair, she keeps records of the businesses or companies who want to rent our place and the amount of guests are able to bowl or just use our clubhouse.
I am curious about how you let the public know that they're welcome. I've visited the website, and it's not immediately jumping out to me. It instantly says become a member, but it doesn't say drop in.
Yeah, well, we do have signs, visitors welcome.
Okay.
You know, I joined after I retired back in 2009. I thought lawn bowling was 10-pin bowling. It wasn't until I actually went in, and when I went in, I was welcome, you know. It was like a sort of family. So they helped me learn the game, and I became a member ever since.
Thank you. I noticed the website says the clubhouse is not available for public rentals October to April, or it says it is only available April through October.
It depends. Currently, I know last week we rented to the Santa Clara Register of Voters for the whole week. And they came in a week ago Friday to set up, and they stayed until Tuesday. And they took apart, they cleaned up the following day. So we, again, plan in November the same thing for the general election. So possibly that is why.
Okay,
There's also times where in the spring and also in the fall, in which the city wants us to close so they can fix the green. They could fertilize and core the green. So we can't use the green but they should be able to use the clubhouse, except for the time when the register of voters come in.
okay, thank you so much. Appreciate your answering my
Okay,
questions.
thank you for having us.
Yeah. So I remain interested in this question of equity across. As city manager pointed out, this is why we're doing this. So to get a better handle on the number of members of the public who are utilizing this resource, I think ultimately we have, tremendous amenities here and resources that we can offer the public. And, we need to make sure that we understand why these 2 acres, for which we receive $16,000 a year, costs us $55,000 a year. What is it? What are we getting, and are we satisfied that we're getting something that we can justify alongside how we're treating Gamble Gardens, Winter Lodge, or somebody that would like this partnership and hasn't kind of bubbled up to the top? So I look forward to, continuing that conversation about why we make the choices we do, and can we really, are we confident that we're doing it equitably? All right, any further comments before we vote?
I mean, do we want to give someone an action to look at metrics and come back, or is that?
Those will already be reflected in the lease that move forward for council approval, and they will be reporting annually on that.
Okay. And how about outreach? Do we want to have discussions with the Lawn Bowling Club and see what kind of outreach they could do?
Yeah, as part of this, these next few weeks, when we'll be looking at that lease vehicle, we can certainly look at opportunities where they could amplify their message and see how we could also list it on our website, if that's something
Could
that.
we do some matchmaking? For example, high school kids or junior high kids, they don't know whether to go on the lawn bowling, and the lawn bowling doesn't know who to contact if they wanted junior high students. And so how could we facilitate that?
Yeah, I feel like we could, during this next few weeks, advise the Palo Alto Lawn Bowls Club on outreach strategies with the high school, and ways that they could engage youth and intergenerational connections.
And could we tell the youth council, for example, this is an opportunity, and then the youth council could reach out to the lawn bowling?
Yes, definitely.
Because it is such a beautiful facility, I really want to make the most of it.
Thank you for that feedback.
All right, let's take a vote.
Let me know if any revisions are required before I take a vote, please.
To that motion, I just also am wondering if we could also include formal support of the framework, just to kind of formalize that and conclude that piece of the work plan.
Yeah, it's whatever was the staff recommendation in the memo.
The staff recommendation actually says, continue discussion of the nonprofit partnership work plan on long-term lease framework and recommend a council extend the Palo Alto Lawn Bowls lease. I'm not sure that we've had the framework in front of us.
So We had, I think, the bulk of the framework discussion at the November 19th Policy and Services meeting, and then we continued that through the leading examples. So we had on that November 19th, the bulk of the discussion with Gamble Garden, and then we came back specifically with Winter Lodge Tennis, and then again now with Lawn Bowls Club. So it's kind of been, I guess, a meandering of that discussion. But the tenets are those that were presented today and described in the staff report, which was the public benefit of the partnership, the financial relationship, and stability of the partnership.
So those three prongs are the
Yes.
framework?
Yes.
Okay.
I just need a little bit of help on wording this, please. Would it be that the committee wants to approve the nonprofit partnership work plan or recommend the council approve?
The committee recommends that council approve the long-term lease framework and extend the Palo Alto Lawn Bowls lease. Is that right, Ms. Almos? Okay.
Yes, that's correct. Thank you.
Thank you.
How about we call it approve the, in front of the word long-term, could you put nonprofit partnership work plan?
Ready for a vote? Councilmember Rectal,
Yes.
Chair Lithcott-Hames,
Yes.
Vice Mayor Stone.
Yes.
Motion carries unanimously.
Thank you so much. Thank you, Ms. Almos. Thank you, Mr. Yee, and your colleague for coming and sharing with us a little bit more about your wonderful program. All right, we'll move on to action item 2. This is a recommendation to the City Council regarding adoption of an ordinance adding new chapter 9.75, Fair Chance in Housing, to Title 9, Public Peace, Morals, and Safety of the Palo Alto Municipal Code to limit the use of criminal history information in rental housing decisions. Director Late, yes,
Great,
welcome.
thank you, Chair Scott-Hames. I'd like to introduce Rebecca Atkinson, planner, who's presented to the City Council on this item before. Ms. Atkinson, if you can take it from here.
Is that on? Okay, good. Good evening, Chair and committee members. This agenda item is, as the chair said, the revised Fair Chance and Housing Ordinance. I'll briefly cover the item history, the main revisions made after council's review in April 2025, and staff's recommendation. Again, I'm Rebecca Atkinson, and Jonathan and I are joined by Madeline Salah and James Reif Schneider. Next slide, please. Tonight, staff is asking the committee to review the revised draft ordinance, receive public comment, and consider a recommendation to City Council. Next slide, please. Fair Chance policy is a part of the city's broader rental policy work in recent years to add more certainty, stability, and fairness in the rental market. On Fair Chance specifically, after discussions with the Human Relations Committee, City Council reviewed a draft ordinance, requested additional analysis, and referred the ordinance to the Policy and Services Committee for refinement. At a high level, next slide, please. Thank you. The revised draft ordinance has the same purpose as originally presented. That purpose includes facilitating a fair opportunity between applicants to compete for rental housing. The ordinance would create a new chapter in the municipal code and would establish procedures for how criminal history may be used in rental housing decisions, if used at all. Next slide, please. City Council's refinement topics focus mainly on look-back periods, such as anchor dates, offense type, and period lengths, as well as specific topics, clarifications on the California Sex Offender Registry, exemptions, and circumvention. Next slide, please. On anchor dates, staff recommends a minor adjustment to use the date of disposition because it is the most reliably reported date. The main reason is administrability. Other dates, such as release from incarceration or other post-conviction milestones, are often unavailable. If the anchor date is not listed, the revised draft allows a directly related conviction to be considered by default while giving the renter an opportunity to show if it falls outside of the applicable look-back period. If the committee prefers a different approach, staff asks the committee to discuss an alternative anchor date structure. Next slide, please. Regarding look-back periods to reflect severity of a directly related conviction, the revised draft now introduces a tiered approach, a 3-year look-back period for misdemeanors and 5 years for felonies. The revised draft uses the conviction classification in the jurisdiction where the conviction occurred. It allows an out-of-state felony to be treated as a misdemeanor if the renter shows it would be a misdemeanor in California. The revised draft also includes exceptions for certain convictions under federal or other state law for conduct that is lawful in California. Staff did not include additional offense tiers, such as for serious or violent crimes, as explained in the staff report. If the committee prefers a different approach, staff asks the committee to discuss an alternative to carry forward. Next slide, please. The revised draft also makes several additional changes in response to council feedback. First, it exempts all single-family residences from ordinance applicability. Second, it clarifies that landlords may consider current sex offender registry status at the time of the background check. Third, it clarifies that the ordinance does not prohibit landlords from using other lawful screening tools, such as employment verification. Staff did not add further anti-circumvention text to this revision because the current draft already relies on providing as clear as possible procedures, documentation, and implementation guidance. Next slide, please. In sum, the revised draft ordinance keeps the core fair chance framework as recommended by the Human Relations Commission while responding to City Council's requested refinements. Staff recommends that the committee provide any further feedback on the revised draft ordinance and recommend City Council adoption of the ordinance. If the committee agrees, staff recommends placement of the ordinance on the consent calendar for a first reading. On a brief administrative note, the published staff report has a footnote numbering issue caused by a software conversion error. The citations are correctly associated with the text, and no footnotes are missing. However, footnote 41 refers to footnote 38. Thank you.
Thank you, Ms. Atkinson. Why don't we go to public comment?
We do have one request to speak. Give me 1 moment.
Perfect. You'll have 3 minutes.
1 second, please. Our first speaker is Hamilton H.
Hi. Long time no see. No, just joking. California already has extensive protections for renters with criminal histories. Under the California Fair Housing Law, landlords cannot use blanket no felons policies, cannot consider arrests that did not lead to convictions, and must show that convictions are directly related to legitimate housing safety concerns. California law also prohibits tenant screening agencies from including criminal convictions older than 7 years. This proposal goes far beyond existing California law. It prevents landlords from conducting criminal background checks until they have made a conditional offer to rent, effectively requiring them to reserve a unit before obtaining information they may consider important to the safety of their property and to other residents. The ordinance then imposes a complex process of notices, waiting periods, individual assessments, written justification, and opportunities to respond. Any mistake can expose a landlord to complaints, litigation, and significant legal expense. This ordinance also contains a major flaw. The look-back period runs from the date of disposition rather than release from incarceration. A person who served more than 5 years in prison could therefore receive these protections immediately upon release without demonstrating any period of law-abiding behavior in the community. According to the CDCR in California, approximately 39% of released prisoners are convicted of a new crime within 3 years, including about 22% convicted of a new felony. Public safety should be the City Council's first responsibility. Palo Alto should support second chances, but not at the expense of the safety of the current residents, including families with children and seniors. I respectfully ask you to reject this ordinance and rely on the existing state protections instead. Thank you.
Thank you. All right, colleagues, who'd like to start us off? Go ahead, Councilmember Rickdahl.
Okay. Yeah, so, and this was sent to staff in 2021, but since then, the Clean Slate Act has been passed. Have you examined the Clean Slate Act? It seems like we're kind of duplicating the Clean Slate Act with this.
The Clean Slate has come into effect, and after a certain period of a demonstrated track record, I think certain convictions can be, eliminated from people's criminal record. It is my understanding is that it's generally automatic, but it also hasn't been in effect for very long, and so. I think people could have their own opinions if it's duplicative or not to have a clean slate in effect as a substitution for a local fair chance ordinance. But I do think that there's value in what the ordinance does outline in terms of when it would come into effect. And it is a 3-year look-back period, which is different than the parameters under Clean Slate.
Yeah, so, I mean, Clean Slate, was part of this was that they were debating what do we do about ex-cons going out and trying to apply. It's just not housing, it's also jobs, it's also applying to be licensed if you want to be a hairdresser or something like that. All these issues ex-cons were coming up against. And the state legislature decided these all have the common problem. Why should we solve it just for housing? So they did this clean slate, and it has some limitations what you can use. If you have a misdemeanor, 1 to 2 years, depending on the offense, it's automatically sealed. If you have no offenses after that, after release. This is after release, not after convictions. And if you have a low-level felony, 4 years after you've completed parole, that's automatically sealed if you have no offenses in that time. And that to me sounds pretty much what we were asking for it last time. The state has already written this. I would think that that would be a better route than trying to write our own legislation. That means that we have to maintain that. It's more both from a financial standpoint and also from a work staff standpoint. I would think it'd be much preferable to say, we were ahead of the city. We identified this before this. We were ahead of the state. We identified this as a problem. We started solving it. The state stepped in and solved it for us. I don't see the incentive to reinvent the wheel. And on top of that, what Hamilton mentioned is, we also have the ICRAA, and that says that if you are renting, you can't use any data that's more than 7 years old, whether that's a bankruptcy, whether that's a criminal background, and all that stuff is also state law. And so between these two things, the ICRAA and the clean slate, I think we've done a pretty good job of solving this problem.
Could we get some guidance perhaps from our legal team on the Clean Slate Act?
Sure. So the Clean Slate Act is in effect, and if, as Councilmember Rectal indicates, those are the thresholds that the committee wants to recommend, then there would be limited utility in passing a further local restriction on when criminal history information can be used. There is still utility when convictions have remained on the record, slipped through the cracks for whatever reason. Commercial criminal history databases are notorious for sort of erroneous, unreliable records. So the value of having a procedure for the presentation of mitigating information or evidence of inaccuracy is valuable there.
And the Clean Slate Act does not allow for the presentation of mitigating information or evidence of inaccuracy?
The Clean Slate Act has to do with the existence of the conviction in the record, but it doesn't regulate the interactions between landlords and renters. So it doesn't have any provisions that regulate those communications.
They're sealing it at the source. And the nice thing about that is then, however that gets distributed, if it's sealed at the source, then you've solved a lot of problems with one act. But I believe the ICRAA does have methods for if you find bad data, you can challenge it. And the landlord, just like we would challenge it. If someone used old data in Palo Alto had to go through some hoop jumping. I think the ICRAA has that same hoop jumping in it for clearing your name if you have erroneous data.
I believe that's correct, but that hoop jumping would be with reference to the credit reporting agency and not the interaction with the landlord. So your remedy might be sort of further upstream, and it wouldn't necessarily help you if you are applying to rent an apartment now and need the landlord to understand that there's an error.
I could be mistaken, but I thought that it also included landlord. But regardless, for me, it's the simplicity. Is like, if we can solve 99% of the problem with the state law, that seems a lot simpler than us recreating that and having a bunch of legislation that we have to monitor and update it to be consistent with the state law.
Thank you. Vice Mayor?
Thank you, Chair. Just following up on Clean Slate. So what's the amount of years then that Clean Slate applies for misdemeanors and then felonies?
I believe it's 1 year from the completion of the sentence for misdemeanors and 4 for felonies.
4 for felonies, and completion of the sentence, meaning like if parole was granted at the end of parole?
That I don't know. I can check.
Okay, yeah, if you could, because that's significant, because you could be released and be on parole for years, and I think then this concern of redundancy is not an issue, because then I think the proposed ordinance will have an impact there, especially since the staff report lays out a strong argument for the most challenging time, and it is kind of shortly after release. So yeah, if you could confirm that, and then it's just you said a year for misdemeanor? Wow. So then, yeah, just kind of a question. If we're doing because I appreciate the 3-year look back here for misdemeanors, I guess just practically, what will that show with the Clean Slate Act? Recognizing, yeah, criminal databases are notoriously wrong oftentimes. So does staff have thoughts on that?
The ordinance as drafted measures the look-back period from the date of disposition, and this is from the Clean Slate Act operates from the date of completion.
And to the question about misdemeanors, do you get parole after, there is no parole after misdemeanor?
I think it's up to a 1-year sentence.
For a misdemeanor?
So, yeah.
Okay.
I believe, if I'm remembering right. back to
Yes,
criminal law?
that's the legal standard. I think custodial sentences for misdemeanor convictions are relatively rare in Santa Clara County.
Nice. All right. Thanks for the criminal law refresher. Yeah, sorry. So I kind of got ahead of myself on thoughts on look-back periods, but let me get a few more questions out and then kind of go to some of my thoughts on this. So one area I'm a little confused about is so are there cutoff periods for look-backs under state law? It's been referenced 7 years for most crimes, but can staff clarify that?
Can you repeat that question, please?
Is there a cutoff period for, under state law, for a look-back period? I think the public speaker referenced 7 years.
7 years is the cutoff for when it can be reported.
Okay, so is there any difference between what kind of state law requires there and what we are proposing besides just that number? I know the staff recommendation is 5 years on misdemeanors, 5 years on felonies, 3 years on misdemeanors, but the actual kind of function of that state law, how is that different than what we're proposing?
So state law, including the state law that limits when criminal history information can be reported, but also state regulations implementing the Fair Employment and Housing Act, include recommendations about procedures for showing that a landlord's policy in considering criminal history information is not going to have a discriminatory effect. But generally, those procedures are encouraged and not required. They're part of a sort of balancing and burden shifting framework that can be analyzed by a judge. But the benefit of having those procedures required and written out in a local rule is that there's a bright line about whether or not they are violated.
Okay, thank you. I think, that brilliant addition of ensuring we're exempting convictions from other states that have criminalized reproductive or gender-affirming care. So well done, staff, kind of flagging that early and incorporating that here. That, to be clear, that is included in the proposed ordinance?
Correct.
Okay, thank you. And I know we got our chief here. Chief, I've got just kind of a general question for you on just kind of thoughts on this ordinance from a public safety perspective. I mean, I think you are the real expert in the room on recidivism rates and risks and kind of exposure to all of this. So just kind of general thoughts on what you think of an ordinance like this and its impact on public safety.
Respectfully, I'd actually defer to staff who drafted as to their familiarity with recidivism and sort of policy on this. I would say certainly from the perspective of a landlord, from just a purely safety perspective, a landlord probably wants access to as much information as possible in deciding who the best tenant is. But I think it's an appropriate policy decision to weigh that desire by a landlord against our desire as a society to allow folks an adequate opportunity to have righted the ship, so to speak, and needs housing stability to continue to be sort of reform their behavior.
Okay, thank you. And any update on the question? Yeah. Okay. So I'm in favor of the staff recommendation of the 3-year look back for misdemeanors. If we are I think that makes sense if we're sticking with the staff recommendation of using the anchoring date as date of conviction or disposition? Are you recommending?
Disposition.
Okay, so I think if we're sticking with that 3 years on the misdemeanors, I know when this came to council, I preferred 10 years on felonies, but now understanding this, I don't know if this change in state law has happened since that council meeting. I think then I think we should mirror then the state look back for felonies at 7 years. Is it 4 years? Wow, so it's 4 years?
It's 4 years from the completion of sentence.
4 years from the, yes, okay, from the completion of sentence, which we're looking into if that includes end of parole. Okay, because that could be a very big window. So we'll need clarification on that. I do think absolutely we should include hate crimes and treat hate crimes as the most severe for, if we're looking at just misdemeanors and felonies, I then think we should treat hate crimes as felony-like with the longest possible look back. Yeah, I would prefer to do the 3-tier approach, treating misdemeanors, felonies, and then serious/violent felonies as different, but I think the staff made a really strong argument in the staff report on how that would be really difficult and kind of inequitable just based on how different states treat different classes of felonies. So I think I'm persuaded there that we can just use that we can just treat misdemeanors and felonies different. And yeah, those are my thoughts. Still need more time on the, okay, sounds good. So I think that remains to be a critical point on our decision making.
Thank you, Vice Mayor. I also appreciate the work to address the fact that people who have been convicted elsewhere might have sort of a different status or terminology in that city versus this, and that we want to bring them in line with how California regards their actions. Also appreciate that we've exempted all single-family homeowners, whether they live in the residence or not. My question, first of all, thank you, Councilmember Rickdahl, for bringing up the Clean Slate Act, because I do appreciate the desire for efficiency, and if it ain't broke, or if someone else fixed it, why are we trying to fix it? And yet there are nuances that the state has not addressed that we might want to at the local level. So my question for staff is, how practical is it for us to incorporate and refer to the Clean Slate Act in our ordinance on the number of years and on the anchor date being the date of release, but then keep our provisions on, for example, a tenant's ability to correct the record and the other protections, the additional kind of tenant-landlord conversational protections that our ordinance includes?
I think that would be workable if those were the thresholds that the committee wanted to recommend.
Thank you. I did read the minutes. Thank you for putting them in the staff report. It was a lengthy conversation, and we were all there from the council meeting. And I think to a person, we were, or almost perhaps uniformly, concerned with the disposition date being the anchor, because it's so long ago, and somebody could have committed a heinous crime a long time ago. And so the look back becomes, it just doesn't feel like it's addressing the situation. But I understand the data is cleaner on the disposition date. So I was surprised. So that's what we were told as a council, that there really isn't a lot of, or the reliability of the data on release dates just isn't anywhere near as robust as it is on disposition date. And so that was the reason staff continues to recommend the disposition date. But now we have the state of California with the Clean Slate Act going with the release date. So why does the state feel confident in relying on the release date, and we should not feel confident relying on the release date data?
When I looked into the Clean Slate Act relative to also what was in the criminal history records and so forth, and the different types of databases and things like that, and I would look into this further, but My understanding is that, that the records can be just out there, and I think that the state is working with itself to close records or seal and so forth, which isn't necessarily the same type of material that may or may not be in criminal history databases. I think that that the record-keeping agencies can work with itself. That was my impression. It was working with itself and not necessarily it seemed like they had the control over that, but they didn't necessarily seem to trickle into some of these other things immediately. I'm sorry that might not be the best explanation if you have.
I'll second Ms. Atkinson's point, which is just that there are reliability of data concerns, record-keeping concerns that come into play when we're talking about private parties, including, credit reporting agencies, that are less salient when we're talking about official agencies relying only on official records that they already have. And I'll answer Vice Mayor Stone's question. The Clean Slate Act does include completion of probation or parole. It does, the 4-year period runs from the completion of probation or parole.
For both misdemeanors and felonies, for all of it.
We would have to, that's certainly the case for felonies. We would have to confirm that's the case for misdemeanors.
Okay, so I'm just trying to run through this, like so you have a landlord and they have an applicant and they want to run a background check, including criminal record, and they go to these databases that are now automatically sealing data because of the Clean Slate Act. They're sealing data about misdemeanors 1 year beyond the completion of the misdemeanor situation and 4 years after felony, including probation or parole. So if those records are sealed, we couldn't go to a 5-year term because the state is sealing those records. We couldn't go to a longer period of time.
So as the ordinance is drafted now, it wouldn't necessarily be a longer period of time because those periods run from the date of the end of sentence and the ordinance is drafted to run from the date of disposition. But your point stands for if the reverse were true.
And I'm revealing my bias, which is I think I'm much more in favor of the release date because it feels like the date of disposition, however more inconvenient it is because it's more, those data are seemingly most often available. It just doesn't feel tied to the ultimate concern, which is how long ago was this person in the system? And we shouldn't be able to ask that question forever. We should be able to ask it for a short period of time after the completion of that rehabilitative process.
That point is taken, and I'll just take this opportunity to add one additional piece of clarification, which is that the criminal history databases that landlords will be pulling from, or that the commercially available criminal history checks will be pulling from, will not necessarily be pulling only from official state records. So if something is sealed as of the date that the record is pulled, it does not necessarily mean that it won't somehow else end up in the commercially available criminal history check.
Sounds like a flock camera situation where different people are dipping into the data. How, you're saying a third party has access to? It's the state or the county that has incarcerated or adjudicated this person.
Yes, our understanding, and Ms. Atkinson can elaborate, our understanding is the commercially available criminal history databases are pulling from sort of a broader net than that. Publicly available data that's just like on the internet.
Yeah. I mean, what the internet says is that once California seals a record, private background check companies are legally barred from reporting or relying on that expunged information for employment or housing.
Right. It would be an error in that case, but it does still happen.
And then is a landlord, so we've acknowledged that maybe somebody has a criminal background from behavior in a different state. And so each state has searchable databases and anyone can search them. Is that correct? And so Clean Slate Act exists here, but if a potential tenant came from Nevada or Arizona and had been involved in the criminal system there, that database could still be searched.
That's right.
There are 12 states that have passed clean slate law. So there it is. California was one of the first ones, and now more have passed. So they would have similar. But regardless, even if they came from a state without the Clean Slate Act, the landlord still cannot use any information that's more than 7 years old. That's California state law. And so if there was a conviction in another state, if that was recent, 3 or 4 years ago, then the landlord still could use that. But if it's 7 years, then that's old information, and California law prevents that.
So my concern about that is it then begins to undo the protections we were putting in place for, you might have done something in Arizona that's considered a felony there, we only consider it a misdemeanor. So in terms of your efforts to get housing here, you ought to have a better shot at it. And so I'm less comfortable allowing that fact to be the inevitable flow that you just described. I'm feeling that the Clean Slate Act is really germane here. And Attorney Saleh's look at me like, no, it's not. You know, I'm always reading your faces to see what you're trying to tell us.
Just listening.
Just listening. And so I don't know if it's best practice for us to say, you know what, the Clean Slate Act seems very germane. Could we ask you to go back, analyze it in the context of what Palo Alto is trying to do, come back with an ordinance that really meshes them based on what you've heard, if that's how my colleagues feel, or are we going to try to kind of massage this from the dais right now? Vice Mayor?
I think it is, but what I think the issue with the Clean Slate Act, based on the clarification from the Deputy City Attorney, is if so 4 years for a felony after completion of parole or probation. Very common in California. Let's say somebody is sentenced to 30 years, maybe they're out in 10, 12 years, and then they are on parole maybe for the next, 18 years or so. That can go for a very long time. And so that Clean Slate Act will not apply until 4 years after they are done with that. All that time, maybe over a decade, the person is on parole, seeking housing, and so that's where I think this ordinance would be able to come into effect. Staff agree with?
And you're advocating for that? That's where you want to go?
As far as the 7-year window. If we want to, if we continue to feel that we want to have a fair chance housing, I think that's an important enough distinction. If we feel like, no, we don't, and state law is sufficient, then it's nice to see that the state law has moved in that direction. But I do see there is I see that they are different enough. I mean, definitely there's some crossover there, but I think they're still different enough that this ordinance will achieve part of our desired effect.
Councilmember Rectal.
Yeah, one of the things I'm struggling with is that we're kind of guessing, well, what's a good lookup period? 3 years, 4 years? And in the state, they would bring in professors who study racism and say, well, how long is it before someone really has reformed? And they have data and they look at that and they make an informed decision. It's still statistics, you're rolling the dice. But I suspect that they're going to be able to do a better job of estimating that probability than we could just here in Palo Alto. And the other thing is that then down the road, if new data shows that, oh, under these conditions, people get redemption earlier, they can shorten that, and we don't have to monitor that and keep on looking at the current data and adjusting that. So I just think we can make a better decision than we would. And when looking at some academic papers about what's the probability for different types of offenses that you're going to recommit after so many years, they did find that release date is by far better than the sentencing date. Just because when you're in jail, you don't mature. When you're out, you're released and you're on your own, you're maturing. And so that type of thing is what the state is studying, is that they're not picking release date versus sentencing date for convenience. They're saying what's most effective.
Thank you for that. And I'll add, the catch-22 is the data also shows that recidivism is less likely when someone is housed. And so as a society, we have an interest actually for the safety and protection of us all to reduce crime, to reduce recidivism. We've got to help people who are coming out of the system get into housing. So it's an interesting competing set of values here. We want to protect society from anyone who's potentially harmful, and we want to help people reenter society and lead a better life, and they need housing in order to do so.
So one more clarifying question. So there's the clean slate, which really has nothing to do with fair chance, like housing issues. It's just record gets cleaned, and so if you are doing a criminal background check, you just can't find that information. And then there's the state's own kind of fair housing law, fair chance housing law that caps the look back at 7 years.
So state regulations implementing the Fair Employment and Housing Act do reference separate state statutes and incorporate the same standard that says this information can't be reported past 7 years. It also, those same state regulations impose other limitations on the use of criminal history information, like, you can't rely on an arrest that didn't result in a conviction. You can't rely on a juvenile conviction, et cetera, et cetera. And one small clarification, I think I might have misspoken when we were discussing the Clean Slate Act in terms of misdemeanors. It is not 1 year from the expiration of the sentence. It is the sentence is completed. The legal standard is 1 year. And it has been 1 year from the date of judgment.
So misdemeanors is 1 year from date of judgment.
And the sentence has been completed.
Oh, and the sentence has been completed. Okay, thanks. So even if let's say we wanted to do a look back period of 10 years on felonies, are we precluded from doing that because of state law? Like 7 years would be the cap that we can do?
I think there would be a conflict with state law. I mean, it gets a little complicated because there are different definitions of different definitions and different information. So I mean, there at least is a potential conflict with state law. Just at a high level, I mean, there are still probably gaps that the city could fill. I think out-of-state data is a pretty significant gap because there are other states that have this kind of statute, but it's a minority of states, and this conversation wouldn't really apply to data from those states. So I think it's a question for council, just sort of like how much of a priority it is to fill those gaps and create a new program, a new ordinance to fill those gaps. The other significant difference about this proposed ordinance is it would give the prospective tenants a remedy against the landlord. And that's a policy decision for council to make, whether it wants to create that remedy. So I think, so I think there's room, I think it's actually a pretty complicated analysis to figure out how, this ordinance would sort of mesh with state law, given the way different, there are different definitions in different places, and figuring out exactly where the overlap is not straightforward, and I'm not sure that has been entirely incorporated into the current draft.
Yeah. It seems like most of the, kind of maybe most of the issues we will see that state law will likely cover for the 7 years, for the 7-year look back.
I would say, I mean, and this is consistent with either the observations Councilmember Rechdal made at the outset, is state law has moved the goalposts quite significantly on what is covered and what is protected. That's not to say that there aren't some gaps left. It's really council's decision whether to address resources to fill those gaps.
Okay. Well, I sent the clerk a draft motion if you'd like me to present one to see. So if the clerk can put the motion on the screen.
And let me remind our colleagues that it only goes to the consent calendar if there's a unanimous decision.
Yep. Thank you for that.
And frankly, yeah, okay, I'll just stop there.
So I think, so I put down, look back period will be from date of release from incarceration when applicable, disposition or sentencing where no incarceration is imposed. When I was looking back on the summary minutes, I agree with the chair. It looked like pretty much we were all aligned that was the better policy. I understand staff's perspective on administrative challenges, but again, to the chair's point, the state is doing that. So I think it does make it a little more administratively burdensome, but I just think it's the right way to go. And then on the look back period, I think 7 years for felonies, then consistent with what state law is. We really can't go beyond that. I do think we should treat hate crimes, whether it's a misdemeanor or a felony, as the same as that 7-year look back. And then I think 3 years for misdemeanors is appropriate, because I think those are the type of kind of potential tenants that were likely more concerned about being locked out of housing when a misdemeanor can be as we're not dealing with violent crimes at that point. So I think this motion kind of achieves the balance and incorporates the feedback that we heard from our colleagues last year, and I do appreciate staff's work on this. I think you added a bunch of things in that we hadn't considered that strengthens this, and really responded to most of that feedback. And I also think too I think the research that staff provided on recidivism rates and how that ties into our policy objectives here are good. I mean, I think clearly the state has good researchers, but we do too, which is great. So thank you to all of you. And I think the research you provided in the staff report was really strong. I mean, so I'll stop there.
Do we have a second? So hearing no second, let me ask you some questions about this because I'm confused. I'm confused about where this 7 years for felonies is coming from, because I heard the Clean Slate Act designates 4 years for felonies after completion of probation or parole. So where is this 7-year piece coming from?
So this 7 years comes from, and staff can clarify the act, but I know you said it a couple times. What's the act?
The investigative Consumer Reporting Act, I believe.
That was the ICRAA
Yeah.
that Councilmember Rickdahl was mentioning?
Correct. And what, I mean, what the statute says is an investigative consumer, thank you, Chantal. But an investigative consumer reporting agency, you know, and we'd be in that situation with this particular report, cannot release a report that includes a report of an arrest, indictment, information, misdemeanor complaint, or conviction of a crime from that date of disposition, release, or parole that antedate the report by more than 7 years. So it's referencing, you know, basically all of those records cannot be drawn in. You know, that said, you know, whatever the most recent of those events, it would be 7 years from the most recent of that event. So it's, so that's what I was alluding to earlier, that there are different definitions in the draft ordinance and the state law. And so there's probably a way to try to make sense of that, but it's a pretty significant intellectual lift to try to put all those pieces together.
Thank you for that. It is complicated, and it seems to me that therefore what the motion proposes is more conservative than state law when it comes to the Clean Slate Act. It's more conservative than the staff recommendation, which was, I believe, was it 3 years for misdemeanors and 5 for felonies? And so the context of this was trying to pass a fair chance in housing ordinance, and we seem to be circling around something that is more restrictive, less focused on the fair chance for the formerly incarcerated people, and taking a more conservative approach, extending the amount of time for these lookbacks. And I'm not sure that that is the direction we were headed as a council.
Yeah, I mean, I think that was part of what the council kind of referred to us to do. Again, I know I was originally supportive of 10 years on a look back for felonies. So for me, this is a bit of a compromise. Up from the 5-year recommendation of staff. Again, I think clean slate doesn't. I think that's something we shouldn't really be concerned about with regards to the felony piece because of the 4 years after parole or probation is completed. So that could be a really, really broad range. I mean, I think philosophically, I think it's a balancing act. I do believe that landlords as well as other tenants should have the right to be able to know to some extent the criminal history, in particular violent felons who might be moving in right next door. If we were able to break it up in a more administratively doable approach, I would then I could see supporting 5-year for felonies and then 10 years or even more for violent felonies. It just seems like that would be really challenging to do. So I think the 7-year, just kind of tying that to the state law seems to be a good compromise here.
So we still don't have a second on this motion. So I think that means the motion.
Do you have an amendment that you'd want to see in order to be able to second it?
Well, I like item 1, defining the look-back period from the date of release where applicable. I am much more interested in the period of time the state has indicated in the Clean Slate Act of the 1 year for misdemeanors and 4 years for felonies as defined in the Clean Slate Act. And I'm interested, I guess the rest of what staff has got in the ordinance is, all we're doing is amending that. So I think I'd feel better with those years. It just feels strange to have the state, with all the research having been done, articulating this period of time for these different types of offenses, for us to come out more conservative than that. I'm not sure we have any justifiable evidentiary reason to need those additional years in this city.
I guess just my response on the Clean Slate Act is, I think you're actually you could be looking at a much longer window of time than 7 years. If it's 4 years after parole is completed, that can be far more than a 7-year time that somebody has been released. So I don't have the data as far as what is the average amount of time that somebody is serving parole, and add 4 years onto that. But I think 7 years could be, I think it's reasonable. That's not too far off of what would the average be. So I don't think the state, I guess my point is, I don't think the state chose that 4 years as a look back period. I don't think that was a part of their analysis. I mean, 4 years after completion of parole, that's a long time. Can be a long time.
Yeah, and you raised that, you said if somebody had been convicted and did 10 years, they might be on probation for 18 years, you said.
Beyond probation, I mean, you could be up to the length of the original sentence, and many people get out after serving a third of their time, half of their time.
Okay, so I guess the state's definition is further extends the period. We had not contemplated probation and parole as a council. We were looking at release or disposition. So I agree with you that that is potentially a very, very long time, which is a concern for me. Councilmember Rectal, you got an assist here?
I mean, this is a hard question, just like OSVs, right? You have bad apples and good apples, and you want to be good to the good apples, and you don't want to be lean over backwards for the bad apples. And so it's a trade-off. And I think the state really struggled with this. And that's all the apartment owners were up there yelling at Sacramento. And I'm afraid that if we try to reinvent the wheel, we're just also reinventing that interaction. And I think the state has done a decent job on this. And for me, it's conservation of resources and also uniformity across cities. Both of those are really good reasons just to stick with the state, unless we think we have a really good, compelling reason not to follow the state. And I haven't seen it, and maybe after more research we'll find out that, oh, there are some holes in this, but I don't see the holes. I think it does a decent job right now, at least from my lay opinion.
But I guess so. If we rely on the state, no, I know we haven't done the analysis, so I won't ask the question. Well, I guess I mean, and then Chair, back to your point that maybe even the 3 years is too long. Seems like under clean slate, the 3 years might not necessarily. So it's what? Because it's a year after conviction and release, right? For clean slate on misdemeanors.
It is a year after the date of judgment, and so two separate conditions. A year has passed since the date of judgment, and the sentence has been served.
Okay, oh, gotcha, okay, yes. So you could have judgment, and then with a misdemeanor, let's just say a year of sentence, then it's a year after that.
No, so both things must be true. The first is that a year has passed since judgment has been entered,
Yes,
and the sentence is complete, but not that a year has passed since the sentence is complete.
gotcha, okay. Okay. So a year after the judgment is entered, so maybe you're sentenced to 6 months.
Yeah, or somebody could, not serve the sentence immediately upon, sentencing and conviction, right?
Yeah.
So there are different reasons, there are different ways it could play out.
Okay. So it's a year after that. So I mean, so if the clean slate law is going to work the way it's intended, our 3-year look-back period here won't matter much.
By which you mean the records will be sealed,
Yes,
except if somebody's coming from a different state that doesn't have a Clean Slate Act.
true. Okay, that's true. So yeah, I think it's still valuable. And would you be more comfortable then if we did the staff recommendation of 5 years for felonies, but keep the 7-year if a hate crime was a part of the conviction?
Yeah, I think so. Let me now try to find the staff recommendation. It's actually, can we find the language that the staff had recommended for the look-back period?
Are you looking for it specifically in the ordinance, or are you looking for it in the staff report?
Well, I was looking for both initially. It didn't make much sense, but Vice Mayor just pointed out to me on
The
slide
slides.
7.
Okay, great.
So the staff report, staff recommendation with so the staff recommendation was with an anchor date of disposition. So we have all agreed that that's less desirable
Yeah.
than the release. But setting the anchor date as the release kicks the number of years that a person can have housing much farther out than if the date was anchored in disposition.
True.
Staff didn't include a recommendation on the number of years if another alternative anchor date was utilized.
Yeah. So be willing to do 5 years.
I feel like there's so much information here. There's so many moving targets. We don't know the average date that a person's incarcerated for a felony or the average amount of time they're on probation or whatnot.
So, Chair Lifkoff-Hames. So just, I mean, we've obviously following the discussion among council here, and, as I mentioned earlier, there are a couple of gaps that council could fill. One obvious one is, out-of-state convictions, and the other would be, some of the procedural protections that are in the current draft ordinance. One approach to fill those gaps and have those procedural protections would be to incorporate state standards to the greatest extent possible in, the timeframes and definitions that we use in the city. Extend those protections to out-of-state convictions, on the same timeframe that apply in-state. And then, again, keep the procedural protections in the ordinance. That's just, it'd be one way to reconcile some of the issues that, we're all struggling with right now. It's obviously, that there are policy implications that council should consider in doing that, but I just sort of throwing that out there as a potential path forward if there's a challenge, coming to a solution.
Thank you, City Attorney Jensen. That is hitting me in a good place. So we can either do a friendly amendment to your motion to, if you're interested in what the city attorney said, or I can start over.
I'll just withdraw the motion.
Okay, we'll withdraw the motion, and then I will move that we recommend the ordinance incorporating state standards to the greatest extent possible. I'm trying to repeat what the city attorney said. Incorporating state standards to the greatest extent possible. What did you say around timing?
Yes, state standards on look-back time and definitions to the greatest extent we can harmonize them with our local ordinance. Extend those protections to out-of-state convictions.
Yes, right. Yes, I'm going to add those. So incorporate the state standards to the greatest extent possible on look-back time and definitions to harmonize with our local ordinance. Incorporate the out-of-state issue.
Correct.
I shouldn't have stopped you. And incorporate the prospective remedies, the procedural remedies.
Yes, yeah, exactly.
Okay, thank you.
And there was the provision about hate crimes. I'm just wondering if that was also part of the motion?
I am happy to include that. Yeah, so I think there wasn't anything on hate crimes in the original. So adding a provision on
Yeah,
period.
so allow landlords to consider hate crimes to the maximum extent permitted under state law it would be the, I think the intent of the vice mayor's proposal.
Okay, thank you. So you'll second.
Okay, I'll just, all second as long as it's, if we change to recommend the city council and just maybe to refer back to policy and services. So I think this is too much and we should see it again.
Yeah, I agree with that. Sorry, I know we want to move as expeditiously as possible, but this has been really quite a hornet's nest of issues, and I think we don't want council to have to go through this same conversation we've just had. So we've got to get some of these things a little bit more ironed out. All right.
The language regarding hate crimes.
Also the procedural protections.
Yes, two more parts, that's correct. Yeah, that's, I think we could work with 3, and then 4 would be to, to incorporate the procedural protections in the current draft ordinance into the revised ordinance.
I wonder if 3 should be revised to allow hate crimes to be considered to the maximum extent permissible under state law, just to.
I do think that that's clear, yes.
Thank you, Madam Clerk. And I believe the Vice Mayor said he would second it if we made those changes. Does it look secondable to you? So the seconder is the Vice Mayor, please.
So I think just on 2, we want to maybe associate that more with the Clean Slate Act. So just so we're drawing that connection, that we're going to apply the Clean Slate Act to out-of-state convictions is the intent. Am I understanding that correctly?
Yeah, I think that incorporates the intent.
It's the definitions.
Correct, yeah.
Does 2, when we're looking at this a couple months from now, is 2 going to give us the direction that we need? Or do we need to add more language to 2?
We could say extend the protections of in-state standards to out-of-state convictions.
I'm just, because I'm definitely totally fine with 2, 3, and 4 being incorporated. Maybe 1, can we say explore incorporating state standards on look-back times, because we don't know what that will look like, and I don't want to fully just lock it in yet. That way, at least we'll kind of see what those standards look like compared to what staff's original recommendation was, compared to my failed motion.
If it's explore, then that's going to be in the staff report as opposed to getting a draft ordinance that does incorporate.
Well, I think however staff wants to handle that, and maybe helpful for staff to kind of provide because I think there's a, I guess what I'm worried about, they incorporate it into the ordinance, and it's doesn't go far enough or goes too far for me or Councilman Rectal or for the chair. It's just because that's I think 2, 3, and 4, we have a good sense right now of what that looks like. 1 is I think is just so unknown to me right now.
Even though I prefer the simplicity of state, I think we're moving in the right direction here. I would say I would just leave it as incorporating the state standards, and if we don't like it when it comes back to us, we can tweak it next time around. Otherwise, we're kind of giving them vague direction if we say explore.
Matt, I don't think it's vague. We generally do that quite a bit. But yeah, I guess for staff, is it easier to just incorporate it now and we then, incorporate it while you're drafting the ordinance, or what's kind of the better approach for you?
So, I think I speak for everybody here that we're going to try to figure out how to make it work. And if there are issues with how that, with making it work, we will make sure to call that to your attention next time we come back. But, I think, at least from my perspective, I understand council's direction and staff will bring back an ordinance that is as close as possible to that direction as we can get.
I appreciate that.
Given the
I
committees and that
would
consensus.
propose a potential amended language, which would be compare state standards on look-back times and definitions and explore the extent to which we can harmonize them with the ordinance. We do want to see the comparison. We want your help with the analysis of the nitty-gritty of what this actually will result in if we go with the state route or the staff recommended route or the vice mayor's failed motion route.
Yeah, I'm much more comfortable with that.
Thank you, Madam Clerk. So it's compare state standards on look-back times and definitions and explore whether they can be harmonized with this ordinance. And we don't need to say Clean Slate Act in item 1 because we all know what we're talking about. Okay, I think we're set. Thank you, Madam Clerk. Please take the vote.
Chair Lithcott-Hames,
Yes.
Vice Mayor Stone,
Yes.
Councilmember Rectal.
Yes.
Motion carries unanimously.
Well, that is how the sausage gets made. It's not even made. It's like partial sausage at this point, but we just got a glimpse of it. We can only hope it'll be very, very tasty in the end. Okay, moving on to item 3. Recommended approval of, and thank you so much to our staff from planning. Thank you, Director Late and Miss Atkinson. Thank you. And to the city attorney staff as well. Thank you so much. And Chief Reifenschneider, thank you. And to everyone, literally everyone who was here, much appreciated. You too, Ms. Cotton Gaines. All right. Item 3, recommend approval of the Office of the City Auditor Annual Risk Assessment and FY 2027 Audit Plan and corresponding task orders. We're going to have our city auditor here, Kate Murdoch. Welcome, Ms. Murdoch. Take it away.
Good evening, Chair and committee members. Kate Murdoch, City Auditor. I will be presenting the results of the citywide risk assessment and proposed FY27 audit plan. Next slide, please. Each year, the City Auditor's Office performs 2 key annual functions, citywide risk assessment and development of the annual audit plan. The purpose of this process is to identify the city's most significant risks and to help ensure audit resources are focused on the areas of greatest importance to the organization and to the community. For this year's risk assessment, we interviewed executive leadership and key staff, facilitated risk workshops, collected input from City Council, and reviewed organizational documents and data. The results of this effort inform the proposed FY27 audit plan, and our objective is to align audit resources with the city's highest risks and highest priority areas while ensuring that we do not duplicate other efforts. Next slide, please. Our methodology follows a structured risk-based approach. We gather information from multiple sources and then consider risks across several categories, including the ones listed on this slide. Once we have a comprehensive list of risks, each risk is assessed based on impact and likelihood to develop an overall risk rating. This comprehensive approach helps ensure we capture both current and emerging risks that are facing the city. Next slide, please. For this year's assessment, we conducted risk synergy sessions with leadership and key staff from 15 departments. These discussions focused on departmental objectives and operations, organizational and staffing changes, and emerging risks and challenges, as well as existing controls and mitigation efforts. We also incorporated feedback from all city council members to ensure strategic priorities and community concerns were reflected in the assessment. And the outcome was a prioritized list of risk areas across the city. Next slide, please. As briefly mentioned before, each identified risk is evaluated using both impact and likelihood criteria, which you can see on the slide. Impact considers financial significance, effects on residents and customer experience, and potential influence on city council priorities and organizational goals. Likelihood considers such factors as the complexity of operations, the regulatory environment, and the effectiveness of monitoring activities, as well as current conditions and known challenges. We also consider fraud risks across the applicable functions. And through this framework, we're able to consistently compare risk levels across diverse city operations. Next slide, please. So kind of the result of some of this work with working with the executive leadership team is what we call the audit universe. It represents the major operational areas and activities that could be subject to audit review across the organization. This year, we revisited operational areas for each department and updated them based on management's feedback. And this is helping to ensure that all significant city functions are considered during the risk assessment process and in the audit plan. Next slide, please. The next 3 slides show the highest rated risks identified during the assessment. The objective of the assessment, again, in the audit plan is to provide assurance and recommendations in areas where improvements can create the greatest value. The arrows indicate the functional areas being included in this year's proposed audit plan. Similar to prior years, this year's plan proposes a mix of both audit and advisory projects. You'll note that there are many possible risk areas that are not on the plan. Some of the things that we consider in determining whether an area is included on the plan or not is whether the area has been recently audited. If the area is currently being evaluated or improved by management, we might defer looking at that area until changes are complete to ensure that audit findings and recommendations are not redundant or irrelevant. So I'll move through the next 2 slides quickly, as I know they're also listed in Appendix C of the report. Next slide, please. You'll note that many of these functional areas and risks involve complex operations, significant financial investments, regulatory requirements, or rapidly evolving environments. And understanding these risk relationships is part of what helps us develop a balanced and strategic audit plan. Next slide, please. This is the final group of top-rated risks. Several of these areas were audited over the last 2 years, including building permit fees, utility billing, and traffic safety improvements. Next slide, please. I'm pleased to present this year's plan. As you'll see, there are 2 proposed audit projects at the top and 4 proposed advisory projects. The first audit project will look at the city's capital improvement project management. Our preliminary objective is to determine if management and oversight processes support timely, coordinated, and cost-effective delivery of capital projects that are operationally ready. The second audit will look at the city's performance metrics across departments to determine if key measures are helping departments to ensure efficiency of operations and that processes are actively being monitored and managed. The first advisory project will look at service models and approaches for supporting and improving outcomes for individuals experiencing homelessness in small cities and see what services might be helpful for Palo Alto. The second advisory project will look at council meeting management best practices. The third advisory project will look at best practices as well as risks related to AI governance, usage, and training for the city to consider. And the fourth advisory project will look at the most effective processes and programs to support employee mental health, wellness, and resilience in high-stress work environments. So this proposed plan seeks to balance assurance and advisory support while also covering emerging risks. We believe this plan will provide meaningful insight and support continuous improvement across the organization. So this concludes my presentation. I'm happy to take any questions.
Thank you, Ms. Murdoch. Let's go to public comment.
There are no requests to speak on item 3.
Okay, thank you. Colleagues, which of you would like to start us off?
I can go.
Thank you. Councilmember Rekdal.
Okay, so when I'm looking at the slides here, let's see, slide 7. And what are the arrows? Those indicate that these are the programs that ended up on that final audit plan?
Correct. Those are functional areas that are being incorporated into the audit plan.
And so when I look at that, there's 5 arrows, but we have 6 elements.
Correct. So AI governance is included in there.
Yep.
I'm trying to think which.
So you split one of them in 2? Is that how we got 6 different elements?
The employee mental health and wellness, I think, is the one that I must have not flagged on here. And I'm trying to recall, apologies. I think it may have been, well, no, that one is on there. Which arrow did I miss? That's a good question. It might have been, oh, let me see. It looks like it was the council meeting management. So that I think may have been one of the medium rated risks, but it was something that was, we got quite a bit of feedback about from council and from staff. That would be a good area for an advisory project.
Okay, and the ratings, is that the multiplication of the likelihood and the impact scores?
Correct.
Okay.
But to Councilmember Rekdal, if I may point,
Yep.
the city clerk item, council meeting management, rated at 12. So how do we justify pulling that all the way up to be one of 6 things that we focus on when there are so many things in that red category of 20 points? Did you hear me, Ms. Murdoch?
Sorry, could you repeat that?
Sure. In furtherance of Councilmember Rekdal's question about where was the 6th item, you discovered that it was the council meeting management item, which comes under the city clerk's office. And I note that it is way down on the list, having scored a rating of only 12. And I find it curious as to why an item with 12 points gets pulled up into an audit plan of only 6 items when we have so many issues that were rated 20 or close to 20. How does something that rated so medium get pulled up to be such a high priority?
So I think that the rating system is really, it's guidance, but it is not a hard and fast, set of, I guess it's not the only thing that we consider when we're looking at how to prioritize what's on the plan. As mentioned, oftentimes there are things on, if you look at that list of 20, there are a lot of items in there that we've already audited. And so some of it is also balancing, we don't want to hit 2 departments, or we don't want to hit a department with 2 audits at once. So that's another thing that we consider. So there are a lot of different factors that we're trying to balance, as well as, sometimes we may look at something that's lower on the list, but is getting a lot of attention from people. So it may not represent a huge financial risk to the city, but it may still be a problem that, or an issue that, requires attention. So,
So for the impact score, did you look at how big a problem is this, or what can we feasibly do? What kind of feasible improvement we can make? Does that make sense?
for that particular item,
Or just in general, because you're giving these scores of impact 1 through 5, is that like anticipated impact? Because if you have a really hard problem that's impossible to solve, but you can make a little impact, versus a really hard problem that you can solve, those would, even though the problems may be the same difficulty, your anticipated improvement might be smaller on one.
Right. So I would say that the impact is really looking at just the potential for the potential impact on the city. So it isn't necessarily can we completely mitigate or triage this problem. That is not part of our scoring. So we do look at kind of financial and reputational and other areas when we're scoring that. We also did have leadership help with the scoring this year. So we did have some of that feedback too. And as much as we try and make it an objective process, it's not a completely objective process. This is, people's perceptions and experience that are helping to inform a lot of this, as well as things like budget documents and a more objective more objective measures.
Yeah, understood. And I think if you're saying that, when you do this risk rating, it's just kind of a guidance of roughly what's important, but it's not like a 16 is necessarily worse than a 15.
Correct.
Yeah. And so do you have a list of what did not make the cut? You had 6 programs here. What was number 7, 8, 9? Do you remember?
Sure. So one of the issues that we did consider was looking at code enforcement. One of the factors that, or one of the things we considered when we looked at whether to have it on the plan was that currently that area is getting significant attention by management. And so things are actively changing. And it's very hard to audit things when they're changing because it's, which period are we looking at? And we're oftentimes then in the report saying, and they're already addressing this and fixing it. So, one of the things that we sometimes will do if an area is under active change is we'll look at it, say, a year out to say, okay, management did all these changes. Are the changes working? Right. So we have data from before the change. Now we're going to look at data after the change. Has it made an actual improvement? So that is one of the items that I have as a possible audit for next year. Another area that came up was the procurement process. So that is one that has kind of been on council's radar for the entire time that I've been in this seat. And one of the things that we thought about there was that we just recently did the contract solicitation and authority levels advisory project. And so I know that the Administrative Services Department is going to be bringing those changes forward in the fall. So again, it was, a lot of the procurement timeliness issues that we might see, we're hoping many of them may be resolved when those contract solicitation levels and authority levels are updated. So it seemed like starting to look at the issue before those changes have been implemented and taken effect might not be the best use of our time. A few other I can talk about. Another area that had come up previously was records retention. So that's just been one that I've been aware of, but it has not been as higher, or it has not been rated as higher risk. Another one that has been on that has come up in various reviews is the permitting process. But that is also a process that has gone through quite a bit of changes. So that's a possible one for next year as well. I would say those are the biggest ones that I can think of right now.
Yeah, that was useful. Thank you. So when you look at the 6 here, were any of these had significant changes, and then this is their first year to be evaluated after the changes?
Sure, that is a great question. Just pull it up for me. So I would say the capital project management, that is just one that has been mentioned a number of times. I'm not personally aware of recent changes, but that's not to say that there haven't been some. The looking at performance measures is, part of that was know that a big council priority is government efficiency. And so really looking at, one of the ways that departments manage resources is having key performance targets and seeing if those targets are helping departments really have a good bead on operations and how they're performing. So that was our attempt to kind of address efficiency across the city and just see, what it's looking like with a broad brush. I am aware that there have been, in the last year, quite a bit is done with oversized vehicles. And I think there's been, certainly a lot in the media about concerns with a growing population of people experiencing homelessness in Palo Alto. So that was an area where it seemed like this might, be a good area to research for the city and provide kind of best practice research of other small cities, different models of services that have been provided, and if there's information on how successful those have been.
Yeah, I think that's a good example, is that it's a really hard problem, but having another set of eyes on that and giving suggestions may be valuable. So I concur. Okay, and so one last question is, looking at this as a wide variety of projects, do you have in-house experts for all this, or are you going to have to hire consultants, or how's that going to work?
Sure. So that's, I think one of the benefits of Baker Tilly is that we are a firm of 11,000 employees and counting. And we really do have subject matter experts in all of these areas. So we have people who have not only worked in these areas as kind of city manager, anything from city manager to police chief to, people who have formerly worked in nonprofits or worked in what am I trying to say, in university and academia, and so have kind of that subject matter expert. So we definitely have people on staff who I can pull from various groups to work on these.
Okay, thank you.
Thank you. Vice Mayor, anything? Okay. I just have a few more questions. Thank you so much for doing this. The $517,000 budget, which this project is stated to cost, is that already been through Finance Committee and it's allocated for the fiscal 27 budget? So this is not a number we have to worry about or pay attention to, right? Okay, Ms. Noze is saying yes.
Sorry, Kate can't see me. So yes, thank you, Kylie Noze, Assistant City Manager, and yes, this is in alignment with your current 2027 proposed budget.
Great, thank you. And to the question of how the big list of potential audit items got winnowed down to 6, and given the ratings and whatnot, I appreciate Councilmember Rechdal's inquiry on that. I was curious as to why then 2 or 4 of them say advisory and the first 2 don't. What does that mean? Does that mean a little bit less attention is paid, or these are more subjective if we have to, like, there's clearly a distinction that's meant to be meaningful, but I don't understand what it is.
Sure. So I would say, in a traditional audit, you're going to have findings and recommendations, and in an advisory project, I would call them more observations and recommendations. They're a little less, finding is not the right word, but we've done a couple advisory projects now for the city, and their intention is more to provide information rather than to identify problem areas. So it's a little bit, I would say the focus is different. So it's not that we won't identify when there are issues, but that our intent is not to kind of quantify those problems. It's more directed at, what are solutions that are out there and what is, what could the city explore?
Thank you, and I noticed that fewer hours, a substantial amount of hours are devoted to each of these, but the greatest number of Baker Tilly hours are devoted to the non-advisory items. So does that correlate? Findings require a greater amount of investment on your part, whereas if it's advisory and you're only making observations, it just requires less time.
Correct.
Okay. I am delighted to see that improving homelessness outcomes made the cut, because you're absolutely right. This is, all of this matters, and yet this is clearly one of the most confounding problems of our existence as a society, as a region, as a city. And I want to be sure, you mentioned OSVs a few moments ago. I want to be sure that the issue of people living in their vehicles is part of the consideration. In many places, that is not yet the lowest level of supportive housing, if you will. It's shelter. And here in California, we now know, nope, there's one level kind of below what we might call a shelter, a homeless shelter. It's, does someone have a safe place to park their car and live in it? And so when you're doing comparables with other cities, they may not be doing safe parking. So please, focus on cities where where they have a percentage of their population that lives in vehicles. It will not help us if you're comparing us to cities that have largely encampments of unhoused people. The majority of Palo Alto's unhoused are in vehicles. Do you get me?
I do.
Okay.
Thank you.
When it comes to council time or council meeting management, I imagine that one of the issues is how long does it take to get an item from start to finish, whatever that means for the item, from start to conclusion, from start to passing it or rejecting it or whatever it is, as opposed to having a lot of eddies where we go around and around, we go back over here, then we come over here and we go, right? Like just tonight, we had a really meaty item and it wasn't yet something we felt we could move forward to council. And none of us is trying to stall the process by coming to that conclusion, but nor should we allow that to happen too often, or else, we're sort of constantly in our own way. So I offer that maybe that's an element that a subheading of this audit ought to focus on, kind of how long it takes to get from start to finish, and how many times are we referring it back and forward and backward and forward. The last thing was for me was employee mental health. You had an arrow corresponding to an HR item that didn't seem to relate. It was human resources, employee benefits, and workers' comp. And I just wonder if that's the best alignment for this item. I'm not sure there
I
was
can speak a little bit to that. I think one of the things that we noted when we did the overtime audit was that there has been an increase in workers' comp cases that are related to mental health. And so this was something that we talked about with HR. Would this be a helpful topic? And they agreed that it would be a helpful area for us to look at, especially for those high stress jobs.
And I can see why additional workers' comp claims present a risk for the city. And we don't want people, being stressed to the level of sort of qualifying for workers' comp. I also see it as an employee retention issue. Like, this city is stressing me out, man. I need to go work at a different place. So I could see it belonging there. I could see it under recruitment. So I just think this is an example of something that's fuzzy. And I don't know how often auditors are asked to audit mental health. What is it? How do we know if it's good? How do we know if it's bad? Who decides, right? It's a very subjective, in the grand scheme of all the things you look at, this is like at the opposite end of anything financial. It's like, how are humans feeling, faring, and doing? So I'm excited that it made the cut. And I want to just acknowledge that this, I don't know who within the Baker Tilly 11,000 employees has like the expertise at the soft fuzzy stuff, but go find that person because this is a different kettle of fish.
Absolutely. We do have a group that does do a lot of performance audit work, and a lot of that is around organizational behavior and structures, and they have touched on these issues with other cities before.
Great, thank you so much. Well, that's it for my questions. Any further questions or comments from my colleagues? All right, then do we have a motion?
I move the staff recommended, pardon, the staff motion, staff recommendation.
I'll second.
The city auditor recommends that the Policy and Services Committee recommend the City Council approve the citywide annual risk assessment and FY 2027 audit plan. Great. We're ready for the vote.
Vice Mayor Stone,
Yes.
Councilmember Rectal,
Yes.
Chair Lithcott-Hames.
Yes, and I note the vice mayor has become a rap star, Vice Mayor Stone X. There's Lil Nas X and Vice Mayor Stone X, so nice to meet you, sir.
Motion carries unanimously.
All right, Ms. Cotton Gaines, is there anything else we need to discuss? Or will you release us for the evening?
Such power you've given me.
We work for you.
Just want to say this is your last meeting before break. Your next meeting will be the second Tuesday of August. I know, go enjoy yourself, do something fun. I believe that's August 11th. I'll have to double check. And I'll be working with the chair on the agenda items for that meeting. In the meantime, enjoy your break.
Terrific. We are adjourned. Thanks, everybody.